If I could have your attention, please. I know there's still some people getting pizza and finding seats, but we're going to get started here. Hi, my name is Peyton Belasco. I'm the president of the Maurer chapter of the American Constitution Society. We're so thankful for having the Office of the Provost and Laura Robel here to attend this event with us, as well as the Maurer School of Law for helping us, the ACS, Maurer chapter of the ACS, sponsor this Constitution Day event. ACS has the privilege of helping to plan the Constitution Day event every year, and it's been an honor this year to help plan it. I would also like to let everyone know that Professor Schroeder will be available for a Q&A in the faculty conference room from 3 to 4:30. There are currently 14 spots left for students to attend that event. There's a sign-up sheet on Professor Johnson's door, on Professor Johnson's office door. So if you'd like to attend between then and now, you can go sign your name up there, and you're more than welcome to attend. So without further ado, Professor Johnson will introduce our speaker, Professor Schroeder.
Thank you all for coming. All right, wonderful to have a full room to welcome Professor Schroeder. Chris Schroeder and I have worked together for more than 25 years on a variety of projects and in government service. And so I'm going to give you a little more personal introduction than some, given that history. We first worked together in Bill Clinton's Department of Justice at the Office of Legal Counsel, providing legal advice to the executive branch and the President and Attorney General. For Walter Dellinger, later went on to be Solicitor General, and one of our, I would say, great mentors in life. We share that. I want to say on a personal level that sometime during that 5-year period I got pregnant, and John and I had our first child, Matthew, and I was just remembering this morning that when I came back after about a month, we had a lot of things going on there, Chris was my boss, and like many women, I was kind of anxious, how am I going to do this? Breastfeeding, and it was just a month after, hormones raging, came in on my door under my nameplate, which was Deputy Assistant Attorney General, was Matthew Hamilton Johnson, Principal Associate Assistant Deputy Attorney General. So that's how you treat women in the workplace. Actually tore apart our study. John, my husband's here. You might not want to go in there. Trying to find that nameplate because I know it's in there somewhere for show and tell. Couldn't find it. I did in my office grab a few things though. So I think this was our first project together. January 22nd, 1993. Clinton cancels abortion restrictions of Reagan-Bush era. So Chris and I, with Walter, helped President Clinton write those executive orders issued right after he took office, and I think there were 6 of them. And so that was exciting, and thanks to my husband for framing that for me. Great memories. And then in academia, these just, on my shelf here, Chris edited this in the Law Stories collection, Presidential Power Stories, and invited me to be part of that. Here's another, I think this may be the last time you were here, but maybe not, Chris. War, Terrorism, and Torture, Limits on Presidential Power in the 21st Century. Former Yale Law School Dean Harold Koh, I think he grabbed a lot of the attention with his title for his talk, Can the President Be Torturer in Chief? That was a good one. Chris and I worked closely together on various, Senate testimony and projects related to George W. Bush and his, what we saw as violations of federal statutes prohibiting torture. And let's see, we also worked, sometimes as lawyers, your best work never sees the light of day. You learn that, but I was thinking about when we worked before Bush versus Gore for Al Gore on what was going to be a fantastic brief that Chris asked me to help author dealing with, you might remember the Florida recount, hanging chads, all those kinds of things. So we worked together on that. And then Chris wrote this wonderful book that I think I get credit for because I asked him to do it, along with Goodwin Liu on the California Supreme Court, Pam Carlin of Stanford Law School. They wrote this book, Keeping Faith with the Constitution, which is fabulous for the American Constitution Society. Okay, I could go on, but now I'll move to the topic for the day and say, Chris, among other subjects like presidential power, separation of powers, administrative law, environmental law, constitutional law, he has a particular expertise on what brings us together here today, and that is the federal judiciary and especially Supreme Court nominations. He served as chief counsel to the Senate Judiciary Committee and special counsel through various nominations. And then most recently, he was President Obama's appointment at the Department of Justice to head the Office of Legal Policy, which has, among its many responsibilities, assists the president on judicial nominations to the Supreme Court and the lower federal courts. So I could go on with stories, but I'm going to leave it there and turn it over to my former colleague and great friend, Duke Law Professor Chris Schroeder.
Thank you very much, Don. That is the best introduction I've ever received. One more down memory lane story about those years. I remember, I'm sure Don does too, that Walter carried around the president's executive orders on a floppy disk. Because, of course, you can't generate these things instantly. It took weeks to draft the various executive orders and get them vetted by all the responsible people, and the technology was such that he needed to carry them, or felt for security reasons he had to carry them in his pocket. So for a while we were all praying that Walter wouldn't get hit by a car or anything else would happen to him before these things became final. So when I was working for the Senate, for the Judiciary Committee, we would hold our regular meetings in 223 of the Dirksen building. This is the middle building of the three Senate office buildings, Russell, Dirksen, Hart. And it was a kind of typical Senate committee room space, which was quite adequate for almost everything we did. But there were two much larger rooms, one in Russell and one in Hart, where, in the words of the Senate had designed spaces for high-interest events attracting crowds that could not be accommodated in the regular hearing rooms. And before Judge Bork was nominated, we used to hold hearings on judges in 223 Dirksen. And we moved to one of the large rooms for the Bork hearings, which were highly televised and, of course, highly anticipated, and ads were taken out for and against the candidate, and it was a very contentious proceeding. And they've never gone back. Everyone since has been held in either the Hart room or the Russell caucus room, which has been renamed the Kennedy caucus room. So whenever you're seeing a backdrop of those hearings, you know you're in one of these big ceremonial and big event situations. And the hearings have become events that everybody takes seriously. The run-up in the media is enormous. The attention being given to them by the press. Cable ratings always pump up at least 50% when they're carrying at least the first couple of days of the hearings live. And now, of course, you can stream whatever aspects of them you want on your devices, or you can go to YouTube and pull down the remarks of your favorite senator, which have been carefully edited by his office and her office and put up on their websites as soon as possible. And there's no sense anytime soon that we'll be going back to a smaller room. It shows you how far we've come, because when the Republic was founded, there were no hearings. And in fact, the Senate confirmed Supreme Court justices in closed executive session. So completely private. Privacy was a big norm in the Senate in the founding era in a way that would be totally unacceptable today. It wasn't until Harlan Fiske Stone's nomination, that a nominee appeared before the committee for any kind of hearing, and he was there solely to answer corruption charges about his alleged involvement in the Teapot Dome scandal. Then Louis Brandeis's nomination generated hearings, but the nominee did not appear. People testified for 14 days for and against him. Justice Brandeis, a judge at the time, stayed at home and got reports about the proceedings. It was actually Felix Frankfurter who was the first nominee to appear before the committee for general questioning. And even then, the practice didn't become routinized until Tom Clark's nomination in 1949. So now they're a regular part of the advice and consent process. And as I say, I don't think there's any sense in anybody's understanding that we'd ever go back to a closed proceeding, and I think they're going to be held in these large ceremonial rooms for as long as I can see, with lots of media attention on a routine basis. At the same time, these hearings are almost universally panned by people who pay the slightest bit of attention to them. The hearings don't tell us much about the nominees' views. The claim is they don't affect the confirmation vote. Everybody seems to have their mind made up ahead of time. They don't illuminate how the Constitution works. They're not a civic moment. Senator Sass said we ought to be having lessons out of Schoolhouse Rock during these nomination hearings, in which we explain how government works and how the Supreme Court fits into this grand scheme of things. So they're almost routinely and roundly criticized. And if you want more colorful language, they've been called useless, vapid, vacuous, a meaningless ritual, an utter charade, kabuki theater, a farce, and a ritual demonstrating over and over again that the senators have become incapable of either properly evaluating nominees or appropriately educating the public. Those are all quotes from pundits, and they're actually quotes from a couple of Supreme Court justices scattered in there, which I can reveal to you if you want to know the provenance of all of them. And the Kavanaugh hearings haven't proven to be any exception to this kind of critical, highly critical commentary. So it's a little like the hearings have become a box office hit that gets a 0 ranking on Rotten Tomatoes. Except the viewing audience wants to keep them on, so they've got some higher number than that. Now, there's a lot to unpack in doing a thorough analysis of the problems with confirmation hearings today. I'm going to focus my remarks on an aspect that's increasingly remarked about, which is how highly partisan they have become. That's actually a quote from Justice Ginsburg in a recent conversation she had at George Washington Law School when she had a colloquy with Goodwin Liu. She called them a highly partisan show, and she wished she could wave a magic wand and return to the days of a less polarized process. And then Senator Sass called them called the Kavanaugh hearings an overblown political circus. And this was in his opening statement before we'd had any of the hearing at all. So he knew exactly what was coming, and many people think he nailed it. So Justice Ginsburg in her remarks referred specifically to her hearing in 1993 and said, the way it was right. The way her hearing went was right, whereas today's process is wrong. And she was confirmed by a vote of 96-3. So let's look at two questions. First, what do you think she meant when she said the way it was right? And what might the Senate do to conduct hearings more in a way that resembled hers? So the first question comes to mind, in my mind at least, because many of those quotes I read you and many of the critical commentaries that people had made about the Supreme Court hearings were made both before and after the Ginsburg nomination hearing. In other words, people didn't think that her hearings had raised the bar very much on the civic value or the public-minded value of the hearings. Almost all of those quotes I gave you, the vapid, vacuous, so on series of quotes, came after Justice Ginsburg's hearings, and they did not carve out hers as an exception, as this an example of one that had gone better. In fact, her hearing spawned a term that is now in common use, the Ginsburg Rule. It wasn't her rule, and she didn't always follow it, but the term was deployed initially by Republicans who used to use it to defend the non-answers that their nominees gave, Chief Justice Roberts, Justice Alito, and Justice Gorsuch. And the term is now stuck. It's almost universally used on talk shows and print media. The Ginsburg Rule simply states that the nominee may decline to answer any question that could be construed to be a comment on an issue that might come before the court. Or in her words, no hints, no forecasts, no previews. In fact, the rule is part of a rhetorical trilogy that nominees have developed over the years, and one that supplies a handy toolkit for skirting substantive questions. Another piece in the toolkit is to say in your opening commentary and then repeatedly throughout the hearings if you're the nominee, if confirmed, I will follow the Constitution. A second is to profess great respect for precedent and to announce that a particular precedent is settled law. And the third is the Ginsburg Rule. So with this toolkit, nominees may decline to let anyone know how they might rule in future cases. They may decline to let you know what they think about past cases. And they can wrap themselves in a kind of rule of law imagery that lots of us and lots of the American people hold about the way courts should operate if things are working properly. Maybe I have to add a fourth element to the toolkit, because in the last several hearings, a fourth trope that you hear quite often is that I'll refuse to respond to hypotheticals. This is used to avoid the effort by some senators to ask a question at a general enough level of approaches to the Constitution or methodology so that they can't be immediately accused of trying to drag out specifically what a nominee would rule in a particular case. Well, that's a hypothetical, and I won't respond to hypotheticals. So there may be four elements in the toolkit now. And the White House, regardless of political party, conducts very sophisticated and exhaustive murder boards or moot courts to make sure that the nominee is thoroughly conversant and knows how to apply the toolkit. The last person who didn't go through murder boards because he thought he was the smartest person in the room was Judge Bork. And that ended up getting him in a lot of trouble, and at least people have taken the lesson, although there are debates about what the specific lessons of the Bork nomination and confirmation fight are. One lesson is the nominee better be damn well prepared to deal with the Senate, not to have a constitutional law seminar in the middle of the hearing room and before millions of people watching on television. So Judge Sotomayor and Elena Kagan were as versed in the trilogy as Judge Kavanaugh demonstrated himself to be. But every nominee brings a personal touch to the trilogy. In Judge Kavanaugh's case, the rhetorical new addition was to invoke what he called nominee precedent. So he now has the ability to look at all of the 8 sitting justices and say, I'm not following actually the Ginsburg Rule. All 8 nominees have responded to questions in exactly the same way, which is true. So he's got nominee precedent behind him to justify the responses that he makes that allow him to avoid answering any particular question that might prove embarrassing in the confirmation process. And you can bet a dime or however much money you want to that the next Democratic nominee will be equally versed in the toolkit. This is a one-size-fits-all education on either side of the aisle. So the toolkit helps ensure that the nominee will reveal very little of substance that is new during their hearings. And of course, it's not true that the nominee says literally nothing about specific cases, but forcing a nominee to be consistent throughout is next to impossible. So you will see nominees talking more expansively about Brown versus the Board of Education, or about the privacy cases, Griswold and Eisenstadt and Pierce and the predecessors, which got Judge Bork in a lot of trouble when he failed to embrace those aspects of the right to privacy during his hearing. But these are all cases that Professor Ringhand and Collins, in a very interesting book on the confirmation process, have argued have become part of the current constitutional canon. Nobody disagrees with them, and it would be extremely unlikely that a nominee who came before the committee for acceptance for a Supreme Court confirmation who expressed skepticism about Brown versus the Board of Education would be accepted. So you will get a little bit of conversation about cases that seem to be part of the current constitutional consensus. And there's some value in that, but at the same time, you learn very little about what the nominee thinks about currently contentious and unsettled issues. Another rationale for sometimes being more responsive than the Ginsburg Rule would suggest is when the nominee has written something specifically about an issue or a case and feels it important to explain it in the light that he or she wants to put on it before the hearing. So Judge Kavanaugh had made some statements that were somewhat conflicting and ambiguous about what the status of United States versus Nixon was, the White House tapes case. And Judge Kavanaugh talked some about that. But aside from these exceptions, you will not get much of new substance or substance about constitutional positions that are still in doubt or up for grabs. And that's a source of frustration for people. Instead, the hearings end up telling us more about the nominee's biography and his or her accomplishments, but how they might approach a controversial question that's on the horizon or just over the horizon, not so much. Now, these frustrations with the content of the responses of each nominee are, well, frustrating, but they tell you relatively little, and they have relatively little to do with why we've moved away from Justice Ginsburg hearings to Judge Kavanaugh hearings towards a more partisan spirit suffused through the proceedings. First, they don't have much to do with it because, as I said, the confirmation hearings have failed to provide much new substantive information for a long time, through and including the Ginsburg hearings. The deficit, or the ratio between efforts to avoid answering specific questions and actually giving you information about constitutional issues, has remained relatively the same in recent years. Judge Bork set a high standard, but Judge Bork had written an enormous amount about a wide number of constitutional cases. He wrote an Indiana Law Review article that said dozens and dozens of cases that the Supreme Court has decided should be overruled. Well, that's enough to get your curiosity up. And he was asked lots of times, what were those cases? And he talked about some of them, and some of them got into trouble. Subsequently, however, nominees have been able to avoid that kind of interrogation. And yet, even though my claim is that Justice Ginsburg's hearings were not that much more substantively informative than any of them have been since Judge Bork, she was confirmed 96-3. So what has changed in the intervening years? It's simply that everything in the United States Senate has become infused with an indelible partisan spirit. Nominees should not be put upon. They are just like every other issue that comes before the United States Senate that is ideologically charged. Political scientists measure the ideological separation between senators on a 1-point scale, where 1 is maximum separation between an extreme person on the right and an extreme person on the left. Or an extreme person on the right and an extreme person on the left. In '93, when she was up for confirmation, that spread was 0.65. Today, it's 0.9. Almost perfect. We're working on it. We're not there yet. So the Senate has become considerably more polarized since her nomination, her confirmation. Another way to measure this is the lack of a political middle in the Senate. So in 1982, there were 58 senators in the space between the most conservative Democrat, a Republican who was more liberal than the most conservative Democrat, and a Democrat who was more conservative than the most liberal Republican. So if that's a hard image, think about this visually. Think about a line, and all the senators line up at the beginning of every Congress according to their ideological voting score in the last Senate. And so just to keep with convention, we've got all the Republicans in red on the right and all the Democrats in blue on the left. And what that 58 number says is that if you look over at the most conservative Democrat and ask how many Republicans are more liberal than that, so they might be occasionally somebody who might vote for a more liberal position. And if you look at the most liberal Republican and ask how many Democrats are more conservative than that, in 1982 there were 58 people there, more than half of the Senate. In 1994, there were 32 people there. Since 2010, that group in the middle could hold its annual party in a very small room because there aren't any people there. All the reds are on the right, all the left, all the blues are on the left. So, according to that measure, we're completely polarized. Now, we're polarized along a kind of ideological dimension. These scores are done on votes where the political scientists think that there is some reason to believe there's a progressive position and a conservative position, and then they ask how the individual senators line up. So it doesn't apply to everything. There's lots of bipartisan work that still goes on. But if it's a contentious political issue defined by that kind of ideology, there's no one in the middle. There's no one to work compromises across the aisle. There's no one, or easily or regularly. There's no one who's open-minded to hearing an argument that's being advanced by the other side. Strike no one and insert almost no one. I don't mean to be universally pessimistic about this. But it is true that since she was confirmed, a very small number of significant ideological pieces of legislation have gotten through the Senate on a bipartisan basis, let alone the House, which is even more polarized than the Senate. Consider the Affordable Care Act, passed exclusively by Democratic votes. The last significant piece of legislation that was produced by the Senate, according to my informal analysis, were the two comprehensive immigration reform bills, one in 2006 and one in 2013, both of which passed by veto-proof majorities, went over to the House, and the House refused to vote on them. This spring, the Senate voted on 4 comprehensive immigration reform proposals, and none of them passed. None of them passed by an amount sufficient to beat a filibuster. All of them died roughly 55-45. So immigration reform has become even more polarizing, or should I say the Senate has become even more polarized, if that is even possible. And I think it's a little of both. I think the last campaign heightened the ideological valence to immigration issues, but also produced a Senate that was even more polarized than before the election. So compromise is very difficult in this environment when your ideological or principled predilections about what good policy ought to be are so different from the other parties, and there doesn't seem to be anything in the middle that is appealing enough to enough people to look like a satisfactory compromise. Now, there's an added problem with a nominee. There's no ability to compromise on a nominee. I can't say, I'll take Judge Kavanaugh if you could layer in a little bit of Judge Hamilton. Some kind of mind transplant. It doesn't work that way. It's just up or down on the nominee. So there's no ability to, as I say, compromise in that environment. So polarization, I think, in the Senate is a necessary condition for making the confirmation hearings polarized and partisan events. It's not a sufficient condition, however, if the selection of an individual to the Supreme Court were thought to be something that ought to be decided on non-ideological criteria, such as judicial temperament, intelligence, legal experience, and other legal qualifications, then you might think there still could be overwhelming votes in favor or against a nominee according to those qualifications. And sometimes a nominee does fail because they lack one or more of those qualifications. If you recall Harriet Miers, who was one of President Bush's nominees for a brief period of time but could not survive the criticism that she was highly unqualified to hold that as her first judicial position. Or you go back to Harold Carswell, who was nominated by President Nixon, who eventually withdrew because of mounting attacks and a likelihood of an unsuccessful floor vote on his nomination. Carswell prompted Senator Hruska famously to say, "So what if he's mediocre? There are a lot of mediocre judges and people and lawyers. They're all entitled to a little representation, aren't they? We can't have all Brandeises, Cardozos, and Frankfurters and stuff like that there." End of quote. So in each case, support of the president's party broke down and the nominee withdrew. But Myers and Carswell are exceptions. The judge-picking process of the White House has gotten better. I think to a person, everybody who's been nominated, through and including Judge Bork, was qualified along these non-ideological criteria. And yet they continue to be more and more the subject of polarized voting. And a fundamental fact contributing to this is simply that interpreting the Constitution, as well as interpreting ambiguous statutes, are activities that reasonable people can disagree about as to what the best answer is. What is more, it's become increasingly obvious that there are distinct approaches in interpreting the Constitution that are favored by conservatives on the one hand and favored by progressives on the other. And they're different. Once a nominee has crossed the threshold of some non-ideological qualifications, the remaining questions of relevance all relate to how they would apply the Constitution in those moments when it doesn't provide a clear answer. And most of the answers on some very high visibility questions of concern to lots of people in the United States fall out along ideological lines. So on questions within the realm of executive power, such as whether the president can pardon himself, whether he can ignore congressional restrictions on interrogation procedures, whether the appointments of independent commissions violate the Appointments Clause, on questions of civil rights and civil liberties, such as whether affirmative action is permissible, whether a woman's reproductive freedom is protected, whether same-sex marriage is guaranteed, whether there's a religious freedom exception to anti-discrimination laws, whether voter ID laws impermissibly disfranchise voters. You could generate a long list of these questions. They all have the same characteristic, which is, generally speaking, conservatives tend to have one answer and progressives tend to have another answer. So the political parties at both the grassroots and the elected officials are more and more polarized into these progressive and conservative camps, and they more and more disagree over what a good justice is in terms of the kinds of answers he or she might give to these questions. Even at the level of constitutional methodology, conservatives favor originalism, progressives favor some of several different approaches that tend toward being more open to supplementing the original understanding with contemporary understandings. So the issue of who occupies a vacant seat on the Supreme Court is ideologically charged, and support or opposition is heavily dependent on ideological considerations. For many people and for many senators, it's just not enough to be qualified according to all the non-ideological criteria. And that's not all. For some of our most ardent citizens, as well as for some senator, the question of who sits on the court is the very most important decision the president and the Senate can make out of all the ones that they could possibly make. It's widely reported, polling results seem to confirm this, that a portion, for instance, of Christian evangelicals continue to support President Trump almost exclusively because they trust him on Supreme Court appointments. And the final ingredient to this recipe of polarized hearings is that those responsible for selecting potential nominees for the president do an increasingly sound job of finding candidates who, by all available predictive measures, will relatively consistently follow one strand or another of the ideological preferences as reflected by the president or his party. They do an increasingly sound job in finding candidates who have their desired approach to constitutional decision-making. So those who say that the views of justices can drift from what they were once they were nominated, become more liberal, become more conservative than they were when nominated, are right from a historical point of view. You can't pick out past instances where drift has occurred. But at the same time, I think the selectors have gotten better and better contemporaneously in choosing candidates who are not terribly likely to drift. I can come back in 30 years, we can look at the current appointees and see if I'm right about that. But I think drift is less and less a concern, and in particular instances can be explained by virtue of the fact that the selection process did not follow this highly information-intensive vetting process that nominees now go through well before the president has an opportunity, him or her, to select them. A major consequence of this is that support and opposition of a nominee has become nearly automatic in the modern polarized Senate. Based on evidence available prior to the hearings, almost all senators have made up their minds before there are hearings. Not a recipe for productive, informative hearings. And nothing short of a confirmation conversion of some relatively substantial type would be anything that the nominee could say that would be said during the hearings that would change or unsettle those expected votes. And this further contributes to polarized hearings. Senators have always been inclined to use more of their time giving speeches than carefully interrogating nominees about things they would like to find out. The utility of hearings for a senator already committed to vote against has been to see if she or he can be helped in making that case against by virtue of something that would come out of the mouth of the candidate. Can you trip up the candidate? Will he or she reveal something that I can then use in my floor speech or in ads against to move public opinion? Well, go back to the moot court process. Candidates are very well schooled, and they're very bright people, and they're highly unlikely to make that mistake, particularly when senators are doing all the talking anyway, and a number of careful back and forths, and let me probe that more deeply, and let me ask you about this, lines of follow-up questions are nearly non-existent. So the toolkit works most of the time. The second best use opposing senators can make of the hearings is simply to make the case against the nominee out of the senator's own mouth. And so that further contributes to the speechification of confirmation hearings. Now that leads to even more contentious hearings as senator supporters of the nominee jump in to defend the nominee. You don't want the nominee having to defend him or herself, but you can have a colloquy between senators that consumes some of the opposing senator's time and shows the case for the nominee in the light that the favorable senators want to present. And so it goes. So that's the case, or that's a particular diagnosis of the causes of the partisan spirit or the overblown political circus aspect of modern confirmation hearings. What can be done to fix it? This is the shorter part of my address. People make lots of clever recommendations about how senators could ask better questions to elicit better answers. Typically these days in op-eds or blog posts that actually lay out a series of questions that would be better for a senator to ask. Some have suggested that majority and minority counsel do most of the questioning. The prospects for these things even being tried, let alone succeeding, are minuscule, and so are any other proposals for reform as long as they focus on the hearings themselves. The tone and major features of the hearings are a product of a larger political polarization in which the country is currently mired. That feature of our politics must be changed before the hearings, which according to my interpretation are no special event, they're just another event in which the ideological polarization of the Senate can be on display in the same way that the failure of an immigration reform vote puts it on display. That's the problem, and that's the feature of our politics that must be changed before the hearings have a chance of improving. It's a long-range project well out of the control of any senator, or the Senate as a whole, to do much about. The senators need to fit into that, we need to find more capacity for fitting into that middle space contrarian senators who are willing to consider other views and moderate their normal preferences and priorities in light of the facts and the contexts. That in turn depends upon the electorate electing people, different people to office, which in turn depends on the electorate being less polarized. And we could have a longer discussion about how polarized the polling data indicates the electorate is. And so that's not an easy problem to surmount. Polarized especially in primaries, where fewer people vote and the tendency is of the more activist members of each party to vote, and therefore you, lots of situations you can cite, get a more left-leaning Democrat or a more right-leaning Republican than perhaps the general electorate would like to vote on. But the general electorate isn't the one who selected the choices. The choices are given to them by the primary process. So my particular solution, I want to draw and close on by borrowing from an experience of a Senate staffer years ago. I'll warn you, the story may be apocryphal, but I've always taken it to have some validity, who worked for a perfectly horrible, despicable individual who happened to be a United States senator. He was mean to staff, arbitrary and capricious in the way he treated people. And this chief of staff had worked with him for a long time and finally got fed up and decided he couldn't take it anymore. But before he announced his resignation, he, as a good staffer, complied with the senator's request to prepare a speech for him. The senator was up for re-election back in his home state on education reform. The senator was a big critic of the administration's views on education. So it was a wonderful speech. The senator delivered it, hadn't, as oftentimes the case, reviewed it before, but it was all done in the voice of the senator because this man was this staffer was a very experienced person, laid out the problem, laid out all of the inadequacies of the current administration's approach, and then he announced that he had a 10-point plan for solving the problem. And he turned the page in his speech, and the staffer had written, "You're on your own now, USOB." Thank you very much.
Thank you so much, Mr. Schroeder, for being here, and that was an excellent, informative speech. We really appreciate it. We have some time for question and answers, I think. I know there are 1:15 classes, so if you need to go, feel free. But one of our 1-hour reps, Trevor Warby, has a microphone, and if you'd like to ask a question of Professor Schroeder, he will select people to ask.
Why don't you take over?
Sure. All right, let's start here.
Thank you very much. Is this on?
Yeah.
Yes.
Yeah.
Thank you very much, Professor Schroeder. you will detect that this is a question from an undisguised activist. So beware. But, and perhaps it takes you too far afield from the subject of your talk. But based upon what we know, not so much from his testimony as from his other writing, what can we infer about Judge Kavanaugh's view of executive power? And how do you feel about that?
Well, I'm not going to give you a specific answer because, frankly, I haven't read everything the judge has written or decided on in the bench or his published dissents. What little I do know would suggest that this is an area in which, by virtue of his habeas decisions, some of what we know about his opinions when he was working in the White House, I'd have reasons for concern that he has a too expansive view of executive authority. He ducked, of course, all the specific questions at the hearings using the toolkit on this subject. But it'd be one of the areas of concern I would have, certainly if I were a senator or working for a senator.
So, given the recent allegations that came out and kind of operating on the Thomas precedent, do you think that Kavanaugh will be confirmed, and do you think that there will be an additional extension of the Judiciary Committee's investigation in the matter, and then still have a floor vote on Kavanaugh?
So the good judge said in his hearings, I'm going to stay 2 zip codes away from political controversy. I just don't know the answer to that. It's too much of a fast-moving script. I heard some news this morning. It could be overborne by events even as we're sitting here. I think a lot of people are concerned that the woman who's come forward at least deserves a hearing, an audience, but how that's going to be done, the committee has different options. I don't know which one they're going to be choosing. So I think it's just too early to speculate one way or the other.
Take a couple more questions.
So you mentioned that there were four tools in the toolkit that they can use to avoid answering the hard questions. So if you could prohibit the use of one of those tools in the toolkit to best, I guess, disincentivize the political partisan nature of this debate, which one do you outlaw and why?
Well, if I take the world as relatively fixed in terms of the norms and procedures in the Senate, I can't actually outlaw any of them. I mean, for as long as I've been knowledgeable about what's going on before the Judiciary Committee, chairman or chairwoman, women have taken the following view on what's appropriate questioning. They've said, a senator can ask any question he or she wants, and a nominee can give any answer he or she wants. And then you leave it up to the senators to decide whether the answers satisfy you or not. And that, I think, is going to remain the ground rule. I can't see any set of political forces that would try to announce rules that restrict the nominee from answering. Can you imagine how that would play out? Then the chairman would have to gavel and announce an evidentiary ruling before millions of people and get into a harangue with, if I were a nominee, I'd bring my own counsel, schooled in evidentiary expertise, who would stand up and object to the ruling. We need a chair to decide whether it goes to the full committee or not. I think it would devolve into a circus that would prove to be unadministrable, and you'd fall back on this other rule. So the committee might have a norm. We disapprove of saying I won't respond to a hypothetical answer, but then the basic rule would be a senator gets to ask any question she wants, a nominee gets to give any response that she wants.
I think we'll get the last question to Professor Johnson. The appropriate,
I think we can go to one.
so. Okay.
Yeah,
Well, that's not.
we can keep
Okay.
going.
Sure.
I don't want to take the last question, so but I have 2 questions. I do have 2 questions. So I hope they're not the last 2. But okay, so one is so I'll say we actually co-authored with a couple of other people a letter to the Senate Judiciary Committee with some of our concerns about and questions that should be asked about executive power of Brett Kavanaugh, and so. that leads me to two follow-ups to David's question. So one is, how about the lack of production of documents from his time in the White House that would help answer some of those questions?
Yep.
I'd like to get your thoughts on that. By some reports, 93%, some senators said, of what we need, we don't have,
Yeah.
and the timing of it all. And then the other question is, are there any issues that you can think of that could come before the Supreme Court related to the current controversy with our current president, where it could matter what a Supreme Court justice's views are on presidential power? And I know you've written about the unitary executive theory and that kind of thing, and just wanted to ask for additional thoughts on those two questions.
Sure. Well, on the first, I have very strong views that hearings ought to be conducted in an environment in which the senators are either reasonably satisfied they've received all the documentary considerations that they think are relevant, or there's a plausible argument as to why they should be withheld, and there's at least a considerable opinion that that's a sound view. So this is a further indication, well, it's an indication of two things. Really, one is an indication of how the norms of the Senate have broken down. It's a further indication of that. Because Senator Grassley is just riding roughshod over any Democratic objections to whether or not they've received adequate documentation. The other thing it's indicative of is how valuable it is for the Senate, from the point of view of the administration, from the Senate to be in the same hands as the party of the president. Because you can't imagine the same answer to these document requests being given if there were a Democratic chair of the committee. Then the norms would be followed. Well, the value of Senate norms used to be that people followed them, whether or not it served their political interests or not. They treated each other with decorum, and they acceded to reasonable requests that the minority party made, even when the majority had the ability to gavel proceedings to go ahead further. So that's evidence to me of a further devolution, if you will, in the civility of the two bodies. And one area that concerns me about, and I don't know enough to have a definitive opinion about this, but I think the court is fairly closely balanced in the executive power area on the issue of the propriety of some of these independent commissions or independent agencies that have been created. I think we've seen some decisions in recent years that have expressed, where the court's expressed more skepticism that independent commissions cannot be created because they violate the Appointments Clause. There has been no omnibus blockbuster decision that writes that rule in a larger way. They've both been fairly fact-specific in their context. But I think there may be something approaching a majority on the court that could limit the ability of the Congress to enact institutions that would be removed from direct control of the president. So that's an area that gives me some concern, that where Judge Kavanaugh, soon to be, I think, Justice Kavanaugh's vote would make a difference.
Zoe, you have a question? Oh, okay.
Thank you. So I followed your prescription all the way through, and I think I could totally agree with it, that I've come to the view that the nature of the Supreme Court's confirmation process is just downstream from larger political forces that have sorted the parties ideologically for really the first time in our history. But the thing that I keep thinking about is that's quite normal internationally. That, in other words, what was abnormal about American politics was when we didn't have parties that were sorted in this ideological way, where we had such things as, very conservative members of the left-wing party or vice versa. And if you look at sort of other countries, that's how it is. The parties are sorted. And you could tell an interesting story about how we managed to avoid it for so long. It's probably deeply connected to race in the United States and things like that. But now they are sorted. And I'm actually skeptical that anything can or maybe even necessarily should be done about that because it's so common. And there are good reasons to prefer sorted parties. You know what you're voting for one thing. And so what that suggests is maybe the institution of the Supreme Court, or at least the extent of its role in American life, just can't be made to make sense in a world of totally polarized parties. And so what's going to have to change is the role of the court itself, that the sort of, and which, by the way, is also unusual in the United States. Most other countries don't have courts that have roles like ours. So I'm curious about your thoughts on that. That, in other words, you sort of end by saying the electorate will have to change. And I say that's possible, but maybe it's the court that's going to have to change if the electorate would not.
Yeah. So that's an excellent question, and I haven't. You're quite right. There are different ways that the current highly conflicted situation we're in might resolve itself. Political scientists for a long time advanced in the United States what they called the responsible party theory, which was the two parties ought to have distinct platforms, and they ought to get into office, and they ought to run their platforms, and people ought to evaluate the success or failure of their platforms, and then they keep them in or they vote them out at the next election. And for a long time, you remember Ralph Nader running on the thesis that the parties were Tweedledum and Tweedledee, that you couldn't tell a whit of difference between the two. That is certainly not true today. And so maybe there are a couple ways that this could go. One is we would move ourselves into a situation that's more accepting of that kind of sharp division and let the party in power run with their program. There's a problem with that in this system because we don't elect our head of office out of the majority party of the Congress, so you can have split government, and then who do you blame, and what's going on in that situation? Long term, I do think that if we continue this polarized appointments process, which then produces results in decisions that look like they're reflecting the nature of the composition of the court as people understood it during the Confirmation, we'll see the respect for the court go down as this kind of arbiter of our fundamental values, which is something that's taken something of a hit on already. But its ratings are still pretty high. They're now in the mid-60s the last time I looked. In the Republican Party, they're at 71%. 71% of the Republican Party approves of the court. They were at 33% immediately after the Affordable Care Act and the same-sex marriage ruling, which shows you that people are paying attention to what the court is doing on highly contentious issues, and they're factoring that into their evaluation. So that consistently became the view of the people. I don't know where institutionally the court would be. Of course, it's got a lot of embedded capital in terms of respect and the security in the Constitution for the form that it now takes. Maybe you could see jurisdiction stripping legislation becoming more a political issue that the Congress was willing to take up because they were looking at the opinion polls and seeing that that was not going to be immediately shot down. Or you might see the pattern that exists now in a number of, if you list a stream of controversial decisions by the Supreme Court in the last decade, some of them are highly alienating to progressives and some of them are highly alienating to conservatives. So there may be a sense in which the discontent balances itself out. After Bush versus Gore, the opinion approval rating of the Supreme Court stayed almost exactly the same. It's just that there was a wild swing among the Republicans up and a wild string among Democrats down, and they canceled each other out. So that may be another consequence. But it's an excellent question. I don't have the answer to all the different ways. And mine is not the exclusive way, of course, that this matter could be resolved.
I think we do need to end now, but I wanted to remind students, if you have additional questions, we have slots for 3:30 to 5 to join us in the faculty conference room. So my office is 274. Sign up on the sheet there if you'd like to join us, just so we know we have enough space. And so join me in thanking Professor